Next case of the morning is number 2250439, Carrasco v. Henkell. We'll hear first from Mr. Brandt.
May it please the court, Tom Brandt for Officer Henkell. This is a case of mistaken identity in which Officer Henkell is entitled to qualified immunity because appellee did not meet the burden of establishing a rebutting of the qualified immunity. Specifically, appellee did not identify a case in which a police officer was found to have violated the Fourth Amendment under similar circumstances. This case is a mistaken identity arrest, but appellees assert that it is a Franks case. In order to address that, I'd like to just address the basic facts of the case. Appellee was arrested after a middle school student in Ector County Independent School District reported that she had been touched inappropriately by a young Hispanic man who worked at a middle school at Ector County Independent School District and was named Mr. Carrasco. Unfortunately for appellee, he met each of those 5 aspects. This was a mistaken identity arrest. A reasonable mistake does not implicate the Fourth Amendment. In an effort to get around
Counsel, are those 5 facts that you just listed the only facts known to the officer at the time about the complaint?
In the record, that is what is known to the officer at the time. No, in the record, it is alleged that he knew more. We don't have in the record.
Well, we have to take that for true, right?
Right.
Okay, so
Yes.
What more did he know, allegedly?
Allegedly, he knew that there were 3 addresses, 3 different phone numbers. There was a TikTok account associated with one Mr. Carrasco, and that he was allegedly knew that there were 3 Mr. Carrascos at the district. So with that information, essentially, which, of course, if we go past that if we go beyond the record, which we're not supposed to, right? At that point, then you have an officer allegedly stopping the investigation when he reached those 5 points, saying, I think I've got my man, filling out a form or filling out paperwork, which then appears in the complaint as an unsigned, unsworn affidavit, which is important because the theory of liability here is Franks. If you look at the complaint and there's a picture of the document in the complaint, it is not signed, it is not sworn. What you had is Officer Henkell did do some investigation, did write up some notes or document, but he never signed anything. He never swore to anything. And there's no allegation that a magistrate signed a warrant. Nothing in the complaint. There's just a conclusory statement that he caused the arrest. That is not a reasonable inference that can be made in light of the burdens to rebut qualified immunity. Arrests can be made based on an indictment. It doesn't have to be from an arrest warrant. And here, presumably, the presumption, I think, should be not the allegations about the document, but the document itself. Here, the allegation is that that document you see in the complaint was signed. Well, if it were signed, it would have been attached.
So you want us to vacate and remand and order dismissal of the case and let them replead with another copy of the warrant because presumably he was arrested and they showed him a warrant at the time of arrest, right? I mean, this is another documentation matter in a way.
Your Honor, it is, again, I would have to go outside of the record to answer that question, but it is my understanding that it wasn't signed ever by the officer, and I'll represent that to the court. And so whatever the cause of the arrest was, it wasn't a signed document by
So
Officer
it's a
Henkell.
mistaken identity case from two standpoints. Number one, 3 Carrascos, 2 of whom were in their 20s. And number two, mistaken situation about what transpired to cause the arrest, whether it's an arrest or an affidavit, false arrest or an affidavit.
Well, the allegation is that he was arrested, and I have no dispute with that allegation. But I do dispute the inferences that are drawn from the facts that are alleged that it was caused by Officer Henkell. Officer Henkell did investigate, yes, but there's no indication under the Frank's level of liability. As you know, in the briefing, you'll see where we've challenged throughout what are the cases that establish this clearly established line here. And the one that the appellees point to, among some others that don't qualify, is Frank's itself. And Frank's itself cannot clearly establish the law in this situation for any number of reasons. But if you look at where Frank's came from, it came from the criminal courts. It was an exclusionary rule issue saying that veracity hearings, if they are completely, totally barred by the state of Delaware in that case, then in that case, it was a violation of the Fourth Amendment because the U.S. Constitution was offended by the fact that there was evidence in Frank's that the 2 police officers who signed affidavits lied about the witnesses.
Can I ask you this, counsel? I've heard reference to 3 Carrascos. Is it alleged that the Carrasco who was arrested, I guess the appellee, was he one of those 3 or an entirely different Carrasco?
He was Eric Carrasco, the appellee, is not Eric Carrasco, the culprit. There were 3 Carrascos, 2 of which were Eric Carrasco. And the appellee was Eric Carrasco, is Eric Carrasco, and the culprit is Eric Carrasco. And they both worked at a middle school in Ector County Independent School District.
I don't recall from the complaint, but was it alleged that the person who actually did the inappropriate touching taught at a particular school in the county?
Yes, and it was a different middle school than where appellee Eric Carrasco was a tutor. The Eric Carrasco culprit was at a middle school, a different middle school, and he was a substitute teacher. He had a TikTok account, and that was not followed, or I shouldn't say, was not investigated, so that distinction there was not ferreted out.
And is it alleged that the officer knew that the Carrasco that was arrested, the appellee, never worked at the school where the inappropriate touching happened?
No, it was. I don't recall seeing that in the complaint at all. No, it was conclusory allegations about this mistaken identity arrest. But there's a very, very strong argument, or very, very insistent argument, I should say, by the appellee that this is not a mistaken identity arrest. It's a Frank's claim, and accepting that that is their theory, then we have to look at mistaken identity arrest situations in which a Frank's liability claim is made, enter Nerio versus Evans, which does exactly that. And although it is not absolutely precisely every fact similar, it is highly similar. And here you have the Fifth Circuit, this court, looking at a situation in which that arises out of 2 people with the same name, mistaken identity. That's Carlos Nerio. This is Eric Carrasco. But there were 2 Carlos Nerios, 2 Eric Carrascos. And in that situation, the reason the plaintiffs there and the reason the appellees here do not want to go down the mistaken identity arrest theory is because it is a loser.
Did Henkell arrest this fellow?
No.
He didn't, so it's not this. So this is step behind there. It's more like the Melton case.
Yes, and Melton, of course, didn't find a constitutional deprivation.
Well, I'm well aware of that.
Yes, and I know you're well aware of it. I just wanted to emphasize that because that is one of the reasons in which those cases cited, Melton, Hale, Virial, Terwilliger, Wilson, none of those qualify as cases that meet the criteria. It has to have happened before, has to have been similar facts, and has to have found a constitutional deprivation. Melton didn't. Virial has been withdrawn, is going to be heard on Banc. Terwilliger and Wilson post-dated. They came after this. And so what you have is remarkable because even if we didn't have Nerio, we would still win this case because there's no clearly established law that governs in the specifics of this similar fact pattern. But we do have Nerio. And what Nerio tells us is not only can I present to this court that there is no clearly established law, but evidence that in a similar case, this court said, absolutely, qualified immunity is granted. But it's very important, and as Judge Jones, you mentioned, he did not arrest this person. So it's not like he arrested Appley. He didn't sign it. He didn't swear to it. He didn't arrest the person, the Appley. He simply took in a report from a child who said she'd been molested, and he investigated. He obviously made a mistake. He didn't investigate to the nth degree.
Well, one Carrasco, this Carrasco was a substitute teacher, right?
Actually, as I understand it, this
Carrasco
Carrasco is a tutor.
Tutor.
I could have it wrong, but that's my
Whatever a
understanding.
tutor is a tutor a permanent employee?
A tutor is an employee.
But a substitute teacher is more like a contract worker. In other words, you substitute at one middle school, you can substitute at another middle school.
Well, that is true. But I think in terms of the control test, they would be considered an employee because...
Well, I understand they're both employees, but what I'm saying is it is not as if the Carrasco in question was the 7th grade math teacher. In other words,
That's true.
A person in Henkell's position, like me, might not apprehend the technical difference between a tutor and a substitute teacher.
Absolutely, Your Honor, I agree with that. And I think that it was not appreciated by Officer Henkell. And I don't want to get outside of the record here, but it was.
Well,
simply.
obviously not, but I mean, so it all boils down to whether Officer Henkell violated the Constitution by not looking at a TikTok app.
You could put it that way, and we already know what the answer is to that question from the United States Supreme Court in Baker. We know that not only does the Fourth Amendment not guarantee that only the guilty will be arrested, but it also talks and refers to inadequate investigations. The Fourth Amendment does not guarantee error-free investigations. If either one of those situations were true, then we would be overrun, correct? Because if the Fourth Amendment guaranteed only the guilty would be arrested, it would be disastrous. It doesn't reach that far, but to elaborate from
Yes, but the other side of that coin is that officers do have an obligation to investigate such that there is probable cause to make an arrest. You started out your presentation by talking about 5 facts. I assume you did that because it shows sort of he didn't get it right, but he was kind of in the ballpark, right?
Yes.
And so, but these are not the facts of this case. If he had arrested a Mr. Carrasco who's 85 years old and who lives in a nursing home, it would be a different case.
If he's 85 years old and living in a nursing home, he wouldn't be substituting, he wouldn't be tutoring,
Exactly.
He wouldn't be employed. So yes.
No probable cause.
Then I would think there would be no probable cause. Right. But you have to understand, and I've got very limited time, but in the theory of the case, it is that there was omissions, not false statements, omissions. And that means that there has to be an allegation, specific allegations of fact that these were knowing and intentional omissions. There's zero in the record allegations of knowing and intentional omissions. There certainly were omissions because the TikTok account wasn't talked about.
And the other Carrascos were not mentioned. I mean, those are
Right.
omissions. I don't know.
But there has to be allegations of knowing and intentional omissions. Thank you, Your Honor.
Thank you. Mr. Illich?
Thank you. May it please the court. My name is Niles, Illich, and I represent the appellee, Eric Carrasco. Before I begin, I want to acknowledge it's been a long morning, and we appreciate the court having us here. I know it's a lot to hear 3 arguments in a day. Now, counsel's raised several issues, and I think the place to begin is this sort of tension between whether or not this is a mistaken identity case or a Frank's case. And they really turned that on the Nero opinion that Justice Oldham wrote just a few years ago. Now, when we look at the Nero opinion, and I know the court will do that, that is a summary judgment case, which puts it in a little bit different context than what we have here. But it certainly is a mistaken identity case with 2 different people with similar names. But in that case, Justice Oldham addressed mistaken identity and Frank's separately. I think appellant has put them together and contended they're sort of the same thing. What Justice Oldham explained in that case—
Judge Oldham.
I'm
He's
sorry.
not a justice yet.
Forgive me, Judge Duncan, I'm going to do that, but Judge Oldham did in that case is that he separated them. He talked about the mistaken identity argument, and then he turned to the Frank's argument. He said Frank's hasn't been preserved because it was only brought up for the first time on appeal. But even if it was, it wouldn't be persuasive. Judge Jones, did you have a question? Did I interrupt you? Oh. Even if it was brought up on appeal, it wouldn't be persuasive, and it wouldn't be persuasive because of the quality of summary judgment evidence showing that there was no reckless conduct on behalf of Evans, the officer in that case. Now,
Well, you have to have facts. I mean, even under Ashcroft and Iqbal and so on, you have to have facts implying recklessness. And
Sure.
as Mr. Brandt started out in his argument, you have a young Hispanic man who tutored in a middle school
correct, Judge.
with exactly the same name as the person who turns out to be the perpetrator.
Sure, Judge Jones.
I don't understand how you transmogrify that into knowing and reckless disregard.
And thank you for that question, Judge Jones, because
Well, that's the gravamen of what you're arguing.
yes, ma'am, and I'll be happy to address that. I think, as Judge Duncan pointed out, there are other facts. And when we look at the totality of those facts, I think we see the problem and the omission. So, of course, there were other Mr. Carrascos that worked there. But what we don't know, what we've alleged and was not included in the affidavit, is that the officer goes to the HR department. This is in our pleadings at page, I think it's ROA 8. He goes to the HR department. He's given the name and address and phone number of every single Mr. Carrasco that works for the Ector ISD school district in any capacity, whether it's a tutor, a teacher, a substitute. He calls one of them. He doesn't call the others. Now, I assume that all Mr. Carrasco's
And he got no answer, right?
he got no answer, and he didn't follow up. But he did have this TikTok account, and I realize we can disparage TikTok in a lot of ways, and I'm certainly not up here advocating for it. But the importance about TikTok is that the villain in this case, the real bad guy in this case, was telling his class about his TikTok account, and he gives them the unique identifier to go to that TikTok account where it's got a picture of him, and that picture is included.
Well, not all, I mean, I don't know anything about TikTok accounts. Do they always have a picture?
That is outside of the record and certainly beyond I have no idea, Your Honor.
Well, that's why I'm, if you have a Facebook account, is your face always on Facebook? No.
No, not necessarily, Judge Jones, but it's
So
there.
I'm not sure why that gives,
Sure.
is something that amounts to reckless disregard.
But let me see if I can do my best to answer that, and that is that this is not a case like we often see in civil rights cases. In civil rights cases, we often see an officer forced to act in the moment, right? He's got to make a decision like that. That isn't this case. He's got time to do the
I
investigation.
know that's the newest theory for defeating qualified immunity, that when the officers have, quote, time to look at things, then we, the courts, are going to go back beyond that and deny qualified immunity. And I see two problems with that. The first one is that there's no law that says that draws that distinction. And in fact, there's plenty of Supreme Court case law that would implicitly reject that. And the second problem is that would basically remove qualified immunity from any officer as to whom you could say, well, this person had time to investigate.
Well, I think it's incumbent upon him to go and do a reasonable investigation about this, and I don't think he did. And I think we've pled that he didn't.
But unless you've got a real case, you do not have clearly established law.
Well, I do not have, there is no case that I can find that is exactly on point with this. But as the court in yes, Judge Duncan.
Well, so, I mean, I appreciate your candor. Doesn't that mean you lose on the clearly established law point, or
Well,
not?
I don't think so, Judge Duncan. I think that we know that novel facts can get us to clearly established law. And what we have here is a really basic occurrence when we talk about Franks. When we talk about Franks, we talk about a knowing or reckless omission from the affidavit. Every police officer, Franks has been around forever, every police officer knows that when you sign that affidavit, you present that affidavit, you have to present enough evidence and be truthful with the court, give everything you know that is relevant to it, and let the court make a probable cause determination.
Sure, but you know as well as I do that you can't define the clearly established law at that level of generality.
Well, and that's an interesting question, and we know that certainly in excessive force cases you can't do that. But when I see what's done in cases such as Henkell, Kohler, Melton, basically what they're saying is that Frank's liability attaches basically when you have a Frank's violation. And I think it's that way. I struggled with this as I was preparing. I think it's that way because these are really different cases than sort of the excessive force that we usually see. In excessive force, you really need to understand the circumstances that were going on, and it's different. Here, he had time to investigate. We know that has to be thorough. We know that it has to be comprehensive. And we think that Melton, we think that Kohler, we think that Hale, and we think that Franks itself get us across the clearly established line.
Well, how would you articulate the clearly established law then? And it won't be helpful to me if you just restate the rule of Franks.
Yeah, I think that
How
is.
would you?
I think that's what. Forgive me.
No, that's all right. How would you state the clearly established law here, at least in terms of the facts of this case?
I think that the law is clearly, and it's restating the Franks issue. I'm sorry, that's all I have on that, is that when you go forward and put that affidavit, you know that you have to include all the relevant facts. There are cases like Melton that say that. And when you leave out those pertinent facts that would remove probable cause from the affidavit, you have committed a Franks violation, and every police officer in the world should be well aware of that fact.
But a probable cause affidavit doesn't have to state every single fact. It's not a memo.
Correct.
About the entire process of investigation.
Correct, Judge Jones, but there are material
Well, how are the
facts.
courts supposed to go back around that? Because some investigations are very complex. They take a lot of time. I mean, are we supposed, well, a TikTok account, obviously. How do we know that?
Well,
Just because you pleaded.
let me say that the TikTok account, I wish I had something else to rely on. TikTok, I understand, is out of vogue and is a problem, but what I have there is a photograph of the person, right? So often when you do, say, a search warrant, you put a picture of the house in there. So Henkell didn't arrest this man. So maybe what he could have done with the TikTok account was at least gone there, put the picture of the person there, knowing that there are three different Mr. Carrascos, so that if the executing officer goes to
Again, there were two Eric Carrascos, were there?
There were two Eric Carrascos.
And they're both in their 20s.
One in their early 20s, one in their late 20s.
Yes, but when you're at a certain age, they all look alike. And I don't, sorry. And also they're both Hispanic. The distinction between brown and hazel eyes is a very difficult distinction to draw. I mean, there's just so much that makes this look, he draws an inference that is at worst negligent.
Sure. Let me see if I can turn that around, Judge Jones, and say that the villain we're dealing with here is a child molester. The person we're dealing with that really is the problem is out there touching children inappropriately. And it is really important that we go get that person off the street, right? Because the longer he is not in jail, the more he can be out perpetrating his criminal activity. So it is particularly important that we go get the right Mr. Carrasco. When you know there are two Eric Carrascos, one of whom is out there molesting children, you need to make sure that when you fill out that affidavit and you go have that person arrested, you've got the right person. Not so much for my client's benefit, but for the kid in the classroom that Mr. Carrasco is still teaching, right? Because if we don't get the real villain in this case, he's creating more victims. And so when you know that you've got a child molester out there and you've got a person who's not a child molester and they share the name, all of which are alleged that this officer knew, right? He knows all of that. You know their addresses, you know their phone numbers, you need to go find out who the right Mr. Carrasco is so that child molester is off the street. So I think that while there are those facts that you pointed to, I think that they can be looked at from the other way, and we can say that because the officer knew these facts and he knew there were multiple possible people subject to arrest from this, that he had a greater duty to go and do a little more investigation than most people. Now, Judge Jones, I realize you don't love the argument about more time, and I realize that people who represent people on my side make that, but what I'm saying to you is that when you have somebody that you're going to arrest who's a really bad person, it's really important to go get the right really bad person, even if that takes you a little longer.
I understand that, but the origin of qualified immunity goes back to Harlow versus Fitzgerald, which was which I haven't read in a long time, but it was
Me either.
involving and Butts v. Economo, and both of those were cases against people high up in the executive office of the president or the executive branch of government. And, you know, if that argument had had any merit, it would have been decided 50 years ago.
Well, I mean, respectfully, Judge Jones, I have to disagree and tell you that I just think this situation doesn't come up that often. I'm not trying to lump myself in with the people who routinely come up here and make that argument. I really...
Well, actually, it's a pretty new argument, but anyway.
All right. Well,
What did you allege in the complaint about the substance of the officer's investigation?
well, we argued that he went, and I believe this starts on page 8 and runs through page 13 of the record on appeal. He gets the allegation. He goes to the Human Resources Department for Ector County. The Human Resource, I think it's Portillo is her name, I forget, gives him the name of every Carrasco that works for the Ector County District, right? Every one of them. Name, address, and phone number. He goes and calls one of them, doesn't get an answer, doesn't do any more follow-up. He looks at the information in front of him and he decides, well, it must be this one. He's in his 20s, he's male, he's Hispanic, must be this guy, right? The other one is male, 20s, and Hispanic. He doesn't do any further investigation into that. And that is the sum and substance of, and we did allege that I think they worked at different schools. I believe that's in like 21 through 24, paragraphs 21 through 24. One is at Crockett, I think the other is at Ector, but they're at different schools, different jobs, and that he knew, right? He knew there are multiple Eric Carrascos. He simply didn't go and do the work to find out which one was which. And we're certainly not up here saying that a arrest where a person turns out not to have committed a crime should be actionable. That's not what we're saying. What we're saying here is that this required more. When you know there's more than one person who could be the arrestee in this case, you have to go forward and do a little more. Or at least you have to tell the magistrate that there could be more than one.
I think you're also saying that based on the facts you alleged, what the officer did was reckless.
Of course, and Judge Duncan, I think we've been very clear. I realize counsel disagrees that we have said that in our petition, but it is in the record, and I think it's even in a title. Forgive me just a moment. I think it's at ROA 6 and ROA 14, and I think you can even see paragraph 46 in our petition. As a direct result of appellant's action, appellee was wrongly arrested. That's the wrong one. Anyway, I'm sorry. We have made an absolute claim that it was done recklessly, that he knew these things. He should have included them in there. I have the citation here.
We can look at the complaint.
Oh, here it is. ROA 16, and it's discussed at 16 through 19 are the specific allegations of recklessness. And the title of that is Material Omissions in Reckless Disregard for the Truth. Now, to me, that title, followed by 2 pages of allegations, gets us at least under the deferential rules of review at this point to a claim that we made it recklessly. But I don't think there'll really be any dispute at that.
As a matter of background, what happened to your client besides the fact that he was brought in, charged, and then released?
Well, he has to go on to community supervision bond, where he's subject to very specific, strict conditions.
Oh, I see. They put him on bond.
They put him on bond, and
How long was it until this was all worked out?
I don't know, Judge Jones. I don't know. To me, that was a question of damages rather than a question of pleadings, but it is not in the petition. Not in the petition.
Did he lose his job?
He lost his job. He certainly suffered social stigma from this. He was not able to go the normal places that when you're on bond for an offense like this, you can't go to a park, right? You can't go to places where children gather. That's the rule in Texas. And so he suffered all of these sorts of deprivations while this was sorted out. But again, I believe that goes to a question of damages. How much does he ultimately recover in this?
So for all we know, he could have been let out within 48 hours.
Let's say he was let out within 48 hours.
I'm not denying there were damages or reputational injury or whatever, but all right. Let's not go beyond the pleadings.
Right, but even if it was 48 hours, Judge Jones, I think we would still have, the question before the court is still pleading sufficiency, adequacy of pleading, and I think that we have met that. I appreciate the court's time. If there are no further questions, I will yield the balance of my time. Thank you.
Okay, thank you. Mr. Brandt.
On record, page 18, paragraph 67, appears this statement: defendant Henkell's recklessness may be inferred from the proof of the omission itself. My point here is that is the allegation. However, the case law is clear that an omission, the standard for omission, is knowing and intentional. There are no facts to support an inference that this was a knowing and intentional omission. The Franks case and its extensions.
He knew there were 3, and he blew off number 3. He didn't even get a call back from number 1, and he arrested number 2. Why can't I infer that that is knowing and intentional?
Because there are no facts other than that.
What I just said.
Other than those facts,
And based on that, he arrests a guy who's now been arrested for a child sex offense, basically, loses his job.
But if you accept that standard, then said if the investigation is negligent, then it infers knowing and intentional. How do we go from negligent to knowing and intentional? And there's not even pled knowing and intentional, it's pled reckless. And perhaps that's splitting hairs, but that to me,
If those facts were before a jury, are you saying a jury couldn't find that there was an intentional and knowing omission from the?
if that's the only facts that were presented, perhaps that could be inferred, but
Yeah,
that's
in other
not
words,
where
we
we
wouldn't-
are right now. We are at the motion to dismiss
Yeah, and we
stage.
have to take those allegations as true.
However, we have to, let me follow to the end here. Knowing intentional omissions, which what? Caused a magistrate to sign a warrant. Even if you say, okay, there was enough to go with knowing and intentional, which I don't concede, but if you take that, then it has to be something, the omissions have to have caused a magistrate to issue a warrant. There is no pleading that a warrant was issued. In fact, we know that a warrant could not have been issued based on an unsigned, unsworn affidavit. It's not even an affidavit. It's just a document which has not been signed or sworn to. This is a situation, as tragic as it is, it does not cross the line to rebut the entitlement to qualified immunity here. There is no magistrate signing the warrant. There's no allegation of that. So when he's arrested, the inference should be not that we make inference upon inference upon inference that, oh, well, it was a knowing and intentional omission. Oh, it must have been signed by he must have signed it. No, he didn't.
It's alleged that he was arrested. What inference should I draw from the fact that he was arrested?
Well, from the facts, you don't have the,
Reason I could think he was arrested?
you can think that he was indicted.
Could have called the local cops. He said, I think I found the guy, go pick him up.
But that's not alleged.
I understand
facts-
that. Well, I suppose I'm rhetorically answering Judge Duncan's question. In other words, liability attaches to people who caused the arrest to be made. If he caused the arrest to be made, it doesn't matter. But it may not be Frank's unless there was an affidavit.
There's a mental state that's required under.
That was a friendly statement, you know. Okay,
I apologize.
that's okay.
I want to mention one last thing, and that is, in the response to the motion to dismiss and in all the briefing, there's never been a request to replead. So it's not appropriate for this court to remand for repleading. I would ask that has been waived.
Wait, wasn't qualified immunity denied?
It was denied.
You asked to replead.
Well, there's been no request below or here for repleading.
He won.
Yes, but there was no conditional.
I won, so let me replead?
Typically, in a response to a motion to dismiss, there will be two things. Judge, please deny the motion to dismiss. Number two, if you're thinking about granting the motion to dismiss, please let me replead. There was no second portion in the response. And there has never been, since that time, a request to replead. So that's waived. Thank you.
All right, thank you both. We have the cases for this morning, and we'll stand in recess until 9 o'clock tomorrow morning.
All rise.